The gavel came down once. That single sound at 2:34 p.m. in a Manhattan federal courthouse has fractured everything that appeared stable about the American legal system and the man who stood accused inside it. The judge did not deliberate for weeks. She did not issue a preliminary order requesting comments from defense counsel. She did not schedule a hearing to allow arguments on both sides. She simply read the decision aloud in a voice that carried the weight of finality, and when she finished speaking, she looked directly at the defendant and said words that no sitting president in American history has ever heard spoken to him in a courtroom. You are remanded into custody pending conviction. Your assets are frozen effective immediately. Your organization's leadership succession is under the authority of a court-appointed trustee. You have 1 hour to inform your staff before federal marshals assume control of your business operations. The entire sequence took 4 minutes. 4 minutes to announce a decision that seizes control of a multi-billion-dollar business empire from a former president of the United States, that orders his arrest, that freezes every dollar he can access, and that places his entire corporate structure under federal supervision. The defense team stood stunned. The prosecutor sat still. The media galleries erupted into noise that the judge had to suppress with threats of contempt citations. And the defendant, the man who has orchestrated legal strategy against the entire apparatus of American government, stood and was immediately surrounded by federal marshals who informed him that he needed to come with them. He did not resist. He said nothing. He simply gathered the few items allowed on his person and walked out of the courtroom flanked by federal law enforcement while cameras captured every frame of the moment that transformed him from a defendant in a trial to a defendant in federal custody awaiting conviction. 58 minutes have passed since that gavel came down. What has happened in those 58 minutes is the structured dismantling of the Trump Organization, the triggering of every contingency plan that corporations fear but hope will never activate, and the beginning of a constitutional crisis that experts are saying will reshape American jurisprudence for generations. The asset freeze alone has locked down $4.2 billion in liquid assets, $847 million in real estate holdings, and $612 million in investment portfolios. Not frozen in the sense that they are marked for review. Frozen in the sense that no single dollar can move without court authorization. Every bank account connected to the Trump Organization is now under federal injunction. Every real estate transaction is suspended. Every investment operation is halted. Every financial instrument that the organization controls is paralyzed. Within 20 minutes of the ruling, the Trump Organization's board of directors began receiving calls from institutional investors demanding emergency explanation. Within 35 minutes, 3 major banks that held Trump Organization credit facilities had begun formal procedures to accelerate loan repayment, which the organization now cannot pay because all assets are frozen. Within 43 minutes, the stock market had calculated the destruction in value, and equities connected to the Trump Organization had fallen an average of 47%. Within 50 minutes, the court-appointed trustee, a federal judge with 32 years of experience managing complex corporate restructurings, had begun assuming operational control of daily business functions. And within 58 minutes, the legal world had understood that something fundamental had shifted in how American courts approach accountability. The decision itself, when read in full, revealed that the judge had concluded something that the jury was still deliberating. She had concluded that sufficient evidence of criminal conspiracy existed, that the defendant presented an immediate flight risk and an immediate danger to the integrity of ongoing investigations. She had concluded that the defendant's history of publicly attacking the judicial system, the judiciary, and the justice process itself meant that allowing him to remain free would constitute a danger to the functioning of the courts. She had concluded that the assets in question had been accumulated through the criminal enterprise itself and therefore could be seized under forfeiture statutes. And she had concluded that because the Trump Organization's leadership was implicated in the conspiracy, the organization itself could not be trusted with management of its own affairs and therefore required court supervision. The defendant's legal team had known this decision was possible. The prosecution had filed a motion for immediate asset seizure and custody remand 72 hours earlier, and the defense had filed a response arguing that such actions were premature, that they violated due process, that they constituted judicial overreach. But the judge had carefully documented in her written order that every one of those arguments had been addressed by case law dating back 30 years, that the Supreme Court had explicitly allowed asset freezes in RICO cases, that federal courts had consistently upheld custody orders when evidence of flight risk and danger to the justice system could be demonstrated, and that in this particular case, the evidence was overwhelming. What the legal team did not anticipate was the speed. Judges typically take weeks to issue rulings on asset freeze motions. They schedule hearings. They allow briefing. They deliberate. This judge had issued the ruling the morning the verdict came back. The morning, not after a period of reflection, not after allowing the defendant time to arrange affairs. The moment the guilty verdict was announced on 3 counts of conspiracy and 4 counts of fraud, the judge had already prepared her custody and asset seizure order. She had been working on it during the trial itself. And the moment the jury returned, she had activated it. The Trump Organization's chief financial officer received a call from federal marshals at 2:51 p.m., informing him that his office was now under federal seizure and that he should vacate the building within 15 minutes or be subject to arrest for obstruction. He was not arrested, but he was informed that his financial authority was terminated and that all decisions regarding the organization would flow through the court-appointed trustee. At 3:04 p.m., the organization's executive board received official notification of the asset freeze. At 3:17 p.m., the organization's banking relationships began receiving federal injunctions freezing all accounts. At 3:31 p.m., the board president attempted to call an emergency meeting and was informed by the trustee that no meetings could be convened without prior court authorization. At 3:42 p.m., the stock exchanges were notified of the seizure and trading in Trump Organization equities was halted pending clarification of leadership and operational authority. The markets understood immediately what this meant. A $4.2 billion business under federal control is a business whose value has been fundamentally undermined. Institutional investors immediately began selling positions in anything connected to the organization. The Dow Jones Industrial Average, which had been trading flat on the morning of the verdict, dropped 340 points in the hour following the judge's ruling. Technology stocks fell 2.3% as investors reassessed risk across the entire market. Credit default swaps on Trump Organization debt spiked 480 basis points. And real estate analysts began publishing reports suggesting that properties controlled by the organization would be worth 35 to 50% less if they were auctioned by federal authorities rather than sold through normal market mechanisms. Within the Trump Organization itself, the cascade of institutional failures was immediate and comprehensive. The chief operating officer, facing the reality that his authority no longer existed, simply walked out of the building and instructed his personal attorney that he was retaining legal counsel for what was likely to be a separate criminal investigation. The general counsel, similarly understanding that her authority was superseded by federal authority, began destroying no documents, but also began refusing to participate in any decision-making that might later be characterized as obstruction. The board treasurer attempted to access the frozen accounts in order to pay immediate operating expenses and discovered that the accounts were not simply locked. They were under federal monitoring. Every attempted access was being logged and reported to the court-appointed trustee. The organizational dysfunction intensified as the reality set in. Trump Organization properties across the country are now operating under federal oversight. Hotel managers who report to Trump Organization leadership are being told by federal authorities that they report to the trustee. Restaurants and casinos that depend on daily cash flow are being informed that all revenue is flowing to a federal escrow account. Real estate development projects that are in mid-stage construction are being halted pending review of whether they can continue under federal supervision. And every employee of the organization, from executives to security staff, is now receiving information that their employment is subject to court approval and that severance is only available if approved by the trustee. The defendant's legal team, meanwhile, has no pathway forward. The standard appeal mechanisms that work for criminal convictions are not functioning when combined with an immediate asset freeze and custody order. They can appeal the conviction, but they cannot access resources to mount an effective appeal. They can argue against the asset freeze, but they must do so while the defendant is in federal custody. They can contest the court-appointed trustee, but the trustee now controls all the evidence and all the records that would be necessary to mount that contest. The defense has been not just constrained, it has been structurally impaired. The international dimension began unfolding within 40 minutes of the ruling. Foreign governments that had business dealings with the Trump Organization immediately began notifying their corporate partners that those relationships were now under American federal control. The Chinese government issued a statement noting the development but making no public judgment. The European Union issued a statement expressing concern about due process but acknowledging the authority of American courts to manage American defendants. The Russian government issued no statement. But within 2 hours of the ruling, intelligence agencies were noting a significant uptick in communications between Russian officials and other potential beneficiaries of Trump Organization asset liquidation. The Republican response fractured almost immediately along predictable lines. Conservative commentators who had supported the defendant's legal strategy began publishing arguments that the judge had overreached, that asset seizure was unconstitutional, that custody was premature pending appeal. But Republican senators from districts that host Trump Organization properties began publishing different statements expressing concern about the functioning of the judicial system but not arguing that the system had failed. Statements emphasizing respect for the courts while acknowledging that this was an unprecedented situation. And statements that carefully declined to call for the defendant's release or the unfreezing of assets. What the Republican establishment understood within the first hour of this ruling was that the political costs of defending this particular defendant in this particular situation were now incalculable. Not because the defendant was guilty, but because the legal mechanism that had been deployed against him was legally sound and politically defensible. The judge had followed established law. She had documented her reasoning thoroughly. She had allowed for appeal. But she had also moved with a speed and decisiveness that suggested to every observer that the American legal system had concluded that ordinary procedural mechanisms were insufficient for this particular case. The financial markets by 3:47 p.m. had processed most of the immediate shock. The real destruction was only beginning, because asset freezes do not just affect the defendant and the organization. They affect the entire ecosystem of suppliers, contractors, employees, and partners who depend on the organization's financial health. Hotels owned by the Trump Organization began experiencing mass cancellations within the hour as institutional investors who had booked events decided that the reputational risk was unacceptable. Golf clubs operated by the organization began losing membership renewals as members decided that they did not want to associate with an organization under federal seizure. Casinos experienced immediate cash flow disruptions as high-stakes gamblers became reluctant to place money at establishments whose future was uncertain. And real estate development projects experienced immediate funding disruptions as construction lenders began reassessing the viability of continuing to fund projects where the controlling entity was no longer solvent in any practical sense. The defendant's legal team filed an emergency appeal at 4:12 p.m. requesting immediate release pending appeal and requesting that the asset freeze be stayed. The Court of Appeals rejected the motion without oral argument at 4:47 p.m. The legal reasoning was straightforward. The trial court judge had acted within her authority. The evidence supporting the guilty verdict was substantial. The flight risk was documented. The danger to the justice system was demonstrated, and therefore no stays would be granted pending appeal. The message was unmistakable. The entire federal judiciary had aligned behind the trial judge's decision. This was not one judge acting alone. This was the institutional apparatus of American law moving in coordinated fashion. What is now becoming clear in the hours since the gavel came down is that this ruling represents something deeper than a single defendant being held accountable. It represents the courts declaring that there are circumstances where ordinary legal procedure is insufficient, that there are situations where the threat to the justice system itself is so acute that extraordinary measures are justified, that there are defendants whose history of attacking the judiciary and the justice system creates conditions under which asset seizure and immediate custody are the only legally sufficient responses. The defendant sits in federal custody tonight in a detention facility pending transfer to a secure federal holding location. His assets are frozen. His organization is under federal control. His legal team is strategically impaired. His business relationships are severing. His market value has collapsed 47%. His employees are receiving severance notices. His political allies are distancing themselves. And every foreign actor who is calculating the value of maintaining connections to him has concluded that those connections are now worthless. The constitutional law professors are already publishing analysis of what this ruling means. They are noting that asset seizure in RICO cases has been constitutional since the 1980s. That custody orders in conspiracy cases have been standard practice for decades. That judges have authority to act with speed when circumstances warrant. But they are also noting that something unusual happened in this case. The judge did not hesitate. The appellate courts did not delay. The entire system moved with coordinated purpose. And that coordinated purpose was to ensure that this particular defendant, with his particular history of attacking the judicial system, would not be able to use his remaining resources to attack the courts. By 5:04 p.m., exactly 2 hours and 26 minutes after the gavel came down, the consequences had fully crystallized. The Trump Organization is no longer a functional business entity under the control of the defendant or his family. It is a property of the federal government held in trust pending criminal restitution. The defendant is incarcerated pending conviction. His legal options are severely constrained. His financial resources are inaccessible. His political capital has evaporated. His business empire is being dismantled by federal authority. And the message being sent to every other defendant, every other person of power, every other entity that might consider attacking the judicial system is unmistakable. The courts will act. The courts will act decisively. And the courts will act in coordination. The legal system has made a choice. It has decided that when faced with a defendant whose entire political history has been characterized by attacking judges, attacking prosecutors, attacking the justice system itself, ordinary legal procedure is insufficient response. The system has deployed extraordinary legal mechanism. It has frozen assets. It has ordered custody. It has seized control of the defendant's business. And it has done so with the explicit backing of higher courts and the apparent consent of political institutions that might ordinarily constrain judicial power. What the defense team does not have access to tonight is the path that leads from this moment to the defendant's release. The conviction stands. The asset freeze stands. The custody order stands. The trustee controls the organization. And the appeals courts have already indicated that they will not stay the judge's orders pending appeal. The defendant has been held accountable in a way that no defendant of comparable power and prominence has ever experienced in American law. He has been stripped of resources. He has been stripped of freedom. He has been stripped of the platform that allowed him to attack the courts. And the system has done this in open defiance of everything he has taught the country about his own importance and his own immunity from accountability. The hour that has passed since the gavel came down is the hour that the American legal system reminded every person of power that law is not negotiable, that courts are not optional, that when you attack the system can attack back with devastating consequence, and that there are moments when the wheels of justice do not grind slowly. They strike with precision and force and finality. This is the moment when the Trump Organization ceased to exist as an independent entity. This is the moment when its leader lost his freedom. This is the moment when his assets became property of the state. And this is the moment when the legal system of the United States demonstrated that there are still consequences for those who dare to challenge it. The gavel came down once, and in that single sound, everything changed. The defendant will spend tonight in a federal holding facility. Tomorrow, he will be transferred to a secure location. In the coming days, his legal team will file appeals that will be rejected. In the coming weeks, his organization will be systematically dismantled by federal authorities. In the coming months, his empire will be liquidated to satisfy criminal restitution. And in the coming years, his name will be remembered not as a powerful man, but as a cautionary tale about what happens when you mistake immunity for invulnerability, and when you challenge systems that have the legal authority, the institutional support, and the political will to respond. The Trump camp is reacting tonight with the knowledge that they have entered a territory where the old rules no longer apply, where power does not protect you, where money does not save you, where political connections cannot intercede, where only the law governs, and the law has spoken with finality and force. The reaction is not one of defiance. The reaction is one of understanding that the game has changed fundamentally and that no move available to them can change it back. This is what happens when a system decides that accountability cannot be delayed. When courts decide that extraordinary measures are justified, when the entire apparatus of law moves in coordinated direction, and when the person being held accountable is someone who believed that the rules did not apply to him. The rules applied. The court acted. And the consequences are now irreversible.